Here's a question. Should cities be allowed to ticket, fine, or arrest homeless people who sleep outside, assuming they have nowhere else to go? Well, right now, in some of the biggest U.S. cities, like Los Angeles, San Francisco, Portland, the answer is no. A court ruling 2 years ago said, no, you cannot arrest people for sleeping, for being homeless. But now, many of those cities say that constraint on what they can do has made life harder for everyone else.
My grandson is on baseball team. They have to sweep to make sure that there's not needles out there, feces out there.
If I was a homeowner, I wouldn't want me here, which is sad. I mean, I deserve to be someplace.
That court ruling was so sweeping, affected such a big swath of the United States, that now, for the first time, the Supreme Court has agreed to weigh in. Let's go through it. So this case goes back to 2018. A group of homeless people sued the city they lived in. They argued that their constitutional rights had been violated when they were fined and ticketed for sleeping outside.
A homeless woman is heading up a class action lawsuit targeting Grants Pass.
Grants Pass is a small city of about 40,000 people in southern Oregon. It's struggling with the same problem that cities all across North America are struggling with.
Every single municipal park in our city, and there's over 20, I believe, have a population of unhoused people essentially residing there, pitching a tent, resting, have their stuff, and it's become incredibly problematic over the last couple of years.
About a decade ago, the city started writing stricter laws around where people can sleep, like this one. No person may occupy a campsite in or upon any sidewalk, street, alley, lane, public right-of-way, park, bench, or any other publicly owned property. You get the idea. No camping. And campsite, by the way, means, among other things, any place where bedding, a sleeping bag, or other material is used for bedding purposes. So, no sleeping in public. And over the years, the city of Grants Pass handed out lots of tickets, fining people several $100s per violation. According to the city council's meeting minutes, one local official said, "The point is to make it uncomfortable enough for them in our city so they will want to move on down the road."
I have probably at least $6,000 to $8,000 in fines.
We're made to move every 5 days, and if we don't, we get ticketed, kicked out of the park, and arrested. We're made to feel like we shouldn't even exist.
So this goes to court. The plaintiff said, hold on, there are about 600 homeless people in Grants Pass at any given moment, but only around 100 shelter beds.
There are not enough shelter beds by a very wide margin, so it makes it quite challenging for these people.
So their legal argument against these tickets was, how can you ticket me for sleeping? Like, this is just a basic human function. I have to sleep. To say that's illegal when, these are just my circumstances, I have nowhere else to go, that's inhumane. And in 2020, the court agreed. They ruled that Grants Pass was in violation of the 8th Amendment, which prohibits cruel and unusual punishments. The impact of that decision was huge, in part because it enshrined this idea that if a person has nowhere else to go, no shelter beds available, then you can't punish them for sleeping where they can in a public space. But also, when the city appealed, it went to the 9th Circuit Court, whose jurisdiction stretches across 9 states and includes a handful of big cities with big homeless populations. That court upheld the ruling, meaning for the past 2 years, it's been illegal for most of the Western United States to punish people who sleep in public when they have nowhere else to go. And that last part is really important. The courts have said you can ticket someone if a person has perfectly good options elsewhere but just chooses to sleep outside regardless. But this has been contentious all around, with lawmakers of all stripes arguing that this has led to chaos and confusion in their cities.
The city of Grants Pass really drew kind of a broad coalition to its side. You had liberal leaders in cities like San Francisco and Los Angeles saying, to the Supreme Court, please take this case, please overturn the 9th Circuit because our hands are tied.
And after months of pressure, the Supreme Court agreed to weigh in.
Out of the Supreme Court in the small city in Oregon that is about to become the focal point for how cities nationwide can handle homelessness.
The city of Grants Pass argues that the ruling upheld by the Ninth Circuit Court was unworkable because, for starters, if the only way to ticket a homeless person is if they had somewhere else to go, how do you easily check that?
And that's what we heard the justices, especially the conservative justices, saying, well, how's that going to work in practice? How can police officers and social service workers determine, does someone have another place to go? How will they make those findings?
In her oral arguments, the city's lawyer used the original plaintiff as an example, saying she was caught sleeping outside and technically had the option to stay in a local transitional housing center. But she didn't because she had a dog, and dogs weren't allowed. So how do you treat that? Like, can the city fine her because she made a choice? Or, what was she supposed to do with her dog? What kind of choice was that? And different shelters come with different rules. No drinking, no drugs, no romantic relationships, no children even. San Francisco's mayor told the court half of the time they offer someone a bed, it's refused. Instead, they build encampments outside of apartment buildings, schools, senior centers, and other community buildings, forcing families with children, persons with disabilities, and older community members to navigate them. So, cities are arguing they're struggling to do their job of keeping their parks, their public spaces, and their people safe.
Homeless encampments come with a wide variety of public health concerns, not just for the surrounding residents, but also for people who are actually sleeping in or staying in these encampments. Obviously, folks don't generally have access to running water, to toilets. People are generally at risk of things like neglected tropical diseases just by virtue of sleeping outside.
Finally, the lawyers for Grants Pass argue that the city's legislation is constitutional because they're not criminalizing homelessness per se. This isn't targeting the status of being homeless. It targets conduct, camping. And those rules apply to everyone.
They say their laws are applied across the board, that they're not about punishment, that they are targeting specific conduct and trying to keep their city streets safe and healthy.
But the lawyers for the homeless plaintiffs turned things around and said, all of these arguments about safety don't really hold up because there are already ways for cities to ensure that camps are safe. There are laws that regulate drug use, littering, and even laws that allow police to clear encampments if there is some kind of clear threat to public safety. What the city shouldn't be able to do, they argue, is ticket or arrest someone just for sleeping outside without providing them somewhere else to go.
The Grants Pass plaintiffs are saying, look, all we're saying is that whatever you do to regulate homelessness, you can't just make it illegal to be an unhoused person in your town.
At least some of the Supreme Court justices seem to sympathize with that argument.
If a stargazer wants to take a blanket or a sleeping bag out at night to watch the stars and falls asleep, you don't arrest them. You don't arrest babies who have blankets over them. You don't arrest people who are sleeping on the beach.
But on the flip side, some justices seem to ask, if you allow this, sleeping in public, where would you draw the line?
How about if there are no public bathroom facilities? Do people have an Eighth Amendment right to defecate and urinate out?
No,
Is that conduct or is that status?
It's obviously, there's conduct there, and we are not suggesting that cities can't enforce their...
Why not, if there are no public facilities available to homeless persons?
That situation, candidly, has never arisen.
There's a lot of passionate, fiery questioning from the liberals about what are people supposed to do if there's not enough shelter. And then you had the conservatives asking about the practical consequences. Should judges and not policymakers be involved in managing housing policy around the U.S.? And also asking about sort of what would the limits be of their decision.
That decision, whichever way it goes, is expected to clarify what authority local officials across the U.S. have to deal with homelessness in their cities. A decision is expected in June.